Welcome to the Commonwealth Club World Affairs of California. I'm Michelle Miao, a member of the Board of Governors, and we are very happy and thrilled that you are here tonight for this very important conversation, topic, and discussion. We'll be focused on discussing the topic of justice, and we'll be doing that by dissecting two cases that have deeply affected our community. Just some housekeeping items. We are recording for broadcast, so if you can silence your phones, that would be greatly appreciated. There are question cards on your seats, so if you have questions for our speakers today, our lovely volunteer, Adelaide, will be walking around with pencils or pens if you need them, and we'll collect them throughout the evening. We also have a nice reception for you after the program, so stick around to hang out with community. We're going to do that up on the rooftop because it's such a nice day. Without further ado, let's welcome our fierce advocate. She is a chief strategist for Asian American Voices, an Emmy Award-winning journalist, and also the author of Amplify, which is going to be released this May. Let's welcome Dion Lim.
Michelle, thank you so much, and thank you so much to everyone who is here in the audience on a Friday, on a spring break week, to be part of this very important conversation. Thank you so much from the bottom of my heart. Tonight's conversation is happening, I think, at a time when so many in our community are still trying to understand what exactly justice really looks like. Many of us, maybe you feel the same way as I do, feel confused, outraged, or maybe you're hurting on the inside, because this, all as the verdict in the Visha Ratanapakdee case came down, and that man who shoved Grandpa to the ground will serve no additional jail time. How is that possible? I remember I was at my kitchen table when I found out, and I literally dropped the spoon I was holding because it seemed like that could not be possible. We are also centering tonight's discussion around another high-profile case involving an Asian grandmother. Yik Oi Hwang, you may remember, I broke her case all the way back in 2019. But yet, even after all of this time, the case continues. There has been no sentencing. Why is that? I know there are so many other questions similar to that by you surrounding the criminal justice system, so I'm exceptionally grateful to be in conversation with none other than our District Attorney of San Francisco, DA Brooke Jenkins. Please welcome her to the stage. Whew. Brooke, hi.
Hi.
It's been great working with you the past couple of years. I appreciate your candor and especially taking part in this conversation, because I'm sure after these cases broke and the court made their rulings, you were bombarded. And there were a lot of questions, and this is your opportunity to address some of those as best you can.
Yes, I know it has been a long road for this community and for our city, and I'm happy to be here to answer some of those most pressing questions.
Yeah, we appreciate it. You know, I want to start off by saying that these emotions are so raw, centering around the Visha Ratanapakdee case. And there is this sense that justice did not happen. I think that's the reason for so much of this outrage. And even after all of this media attention, I remember the case made it all the way to the New York Times. There were outlets from even rural parts of the country that picked up the story. It was wild. In your purview, was this trial fair?
It's a difficult question to answer. As prosecutors, we are not always going to agree with every ruling from the court. We are not always going to feel that we got the outcome that we worked hard to obtain. But, you know, when we look at a case after the fact, we do our best to assess what happened. We do have the opportunity to talk to jurors sometimes if they're willing to talk to us after a case. But it's It's tough. Sometimes it's a lot to digest. There are often times that I have walked away from my own trials in the past feeling that justice was not served or obtained. And in this case, I think, like everyone else, nothing about the outcome felt fair, whether it was about the trial process or not. Nothing about knowing that this is a man who gets to go home right away feels fair.
How do you deal with that as a district attorney? I mean, the weight of that case among so many, I can't even imagine.
It's hard. It's hard. It's hard when you're the lawyer in the courtroom and that happens. I've, again, felt that really despair almost when you don't feel that you were able to deliver the verdict that you felt the family in particular was entitled to. For us, this is about working hard no matter what to come back to the table, to come back into the courtroom and keep fighting, to not give up, and really to do everything we can, hopefully, to prevent anything like this from happening again.
Yeah, and we'll talk about that a little bit later as we look toward the future and what this means for our community. You touched upon a word that I keep thinking about, despair, because that was how I felt when the first-degree murder charge did not stick. Why do you think the jury landed on involuntary manslaughter instead?
So I will be honest that we as prosecutors knew that this was going to be a difficult case from the start. And I did my best, and I know that the lawyers on the case did their best to be clear with people about what the expectations should be. The reason why I say that it's hard is not because there wasn't clear video evidence of what happened, and us all knowing Grandpa Vicha lost his life, but understanding legally what we needed to prove, we knew would be difficult, meaning we had to prove that at the time of the shove, that the defendant understood that he could cause death, or was likely to cause death, in fact. And normally, when we think about the way that people die of homicide, it is by gun, it is by knife, it is by things where it's very clear that you are using an object that could likely cause death. And here needing to be able to help the jury wrap their heads around why such a violent shove was sufficient in this case. When you line that up with Grandpa Vicha's age, with the force that was used, and so from that perspective, we knew, again, that this was an uphill battle. I think that they got caught up, though, in the defendant's age, that they were not, seemed to be more focus on his age than on the age of the victim.
Yeah.
And that they could not come to terms with the fact that that someone could think that a shove would take someone's life. Even though, for us, the violence that was enacted in that moment in time, when you saw someone's age that you were about to attack, should have been enough.
Yeah, among other things, because I remember unearthing the document from one of my sources that showed that Antoine Watson went back to his car to get a cell phone to then take pictures of Vicha's lifeless body there on the ground. And to me, it just seemed so heinous. And I think it's important for people to understand the way that law works and the way that these proceedings happen. It's complicated.
It is. It is. While most people think that we can introduce every bit of evidence, talk about anything we want, it's much like, I hate to use this analogy, but it's much like sports. There are rules, and there is an umpire or a referee, which is the judge, who determines what we are allowed to say, what evidence is allowed to come in front of the jury. And we spend sometimes days or weeks arguing over whether a sentence can be said or a specific piece of evidence can come in. And so oftentimes we are very limited in the language that we can use, in statements that we can say, in what evidence can come before a jury. And that oftentimes impacts which direction a case goes.
Yeah. And that also reminds me of the elder abuse charge, because I think us civilians, we think everything should be admissible in court. And we also think that it seems so obvious. Grandpa is a grandpa. He's old. So why wouldn't there be an elder abuse charge? What could the reasoning possibly be?
You know, we are off every day. We are making charging decisions in my office. We have over 8,300 pending cases right now. So that is over 8,000 cases, and that is just what we filed. That doesn't mean what we reviewed that we chose not to file. So each and every day we are making decisions on whether to charge a case and then what to charge based on the conduct in front of us. In this particular case, when you have a homicide, when you have someone that we are charging with murder, there is really no allegation other than, I would say, an enhancement like the use of a gun that's going to materially change the sentence exposure. And so in this particular instance, yes, we believe that his age was relevant to what we believed the defendant would have known at the time that he attacked him, but it was not an allegation to add as an enhancement to the murder.
Can we talk about sentencing also? Because time served, something that I've learned is it can vary a lot depending on the charge. So what would something like elder abuse add on to a sentence?
It really depends. It can add a few, 2-3 years, generally at most. So it all depends. And I've had this conversation about hate crimes as well. Hate crimes, for the most part, not completely, but for the most part, are an enhancement to the charge of the actual conduct. And so, yes, we often want to see a true reflection of the behavior on the charging document. But overall, when we look at sentencing, usually it's that underlying conduct that will provide, the bulk or the substance of the sentence.
I do want to talk about hate crimes a little bit later because it's the constant I hear after cases like this. But I also want to address there is always a lot of finger pointing after verdicts come down, finger pointing that perhaps it's a different party, maybe it's the judge that is to blame. What are your observations of the judge in this case? That says a lot.
How do I put this professionally? In my view, and in what I've not only learned from, one of the attorneys that tried this case, but also, or of the attorney that tried this case, but also from my own observations when I attended the sentencing, this was a judge that was hostile to my office in this case. The behavior that I witnessed as far as what was said to the assistant district attorney handling the case, in my view, was completely inappropriate. It seemed very personal. It did not comport, in my view, with the way that a judge should act, particularly in front of the victim's family. And my understanding is that hostility was not reserved for sentencing, but had shown itself throughout the pendency of this trial.
Wow.
Which impacts, the jury sees this at times. This is something that they are witnessing, and they are taking in everything that they are seeing. If a judge is acting a certain way towards one side versus the other, that creates an environment that, quite frankly, could be biased.
I've seen it. People pick up on the energy. They think, oh, the judge must have that bias. I have to say, in the Yik Oi Huang case, the judge was very clear in his displeasure over Mr. Gaithron's behavior, and it was just so refreshing to see. Are you able to elaborate a little bit more on any specifics that you encountered?
Just what I would say is, when there appears to be personal animus and like I said, both to the lawyer, both to my office, because I believe this is a judge who simply is biased towards any case that we bring in front of her, it can impact rulings. It can impact decisions that are made about what questions we are allowed to ask, what evidence, like I said, can come before a jury. And it can create a level of distrust of the prosecutor, and sometimes, these sentiments are directed against the defense in certain instances. So I'm not saying that can't happen, but in this case, it can create an environment of distrust of the prosecutor if the jury is seeing these types of interactions. And like I said, what I witnessed during the sentencing appeared to be an unwarranted, unsubstantiated set of accusations and personal attacks that were intended to undermine the attorney in front of both the press and the victim's family.
Thank you for sharing that. The judge also has control over what evidence is admissible as well. Did that play a role?
So I know that there have been some statements. I know that there have been questions about this. What I have to be honest about is that I am limited as a prosecutor in what I'm allowed to discuss publicly. And a part of that is because our job is to not undermine the trust in the criminal justice system. It's to maintain that trust among people like yourselves who any day now could get a jury summons and have to be able to walk into the courtroom believing that you can be fair and impartial and that you will be given the information that you need in order to serve as jurors. And so in many cases, there are disagreements over what evidence can come in and cannot come in. That is standard in any trial, and this was no different.
And we mentioned the jury. In this case, as with so many others, jury trials, the outcome can be difficult to predict. Is that right?
It's impossible to predict.
Yeah.
Impossible. There have been cases that I prepared for, went into trial thinking this is clear as the sky is blue, what happened here, and can sometimes have a jury acquit or have one or more jurors say that they just can't figure it out and the jury hangs. We are very clear as we train our lawyers that you can never take for granted what a jury may do. Yeah. It is completely unpredictable.
Is that why you try to avoid it if possible?
You mean in settled cases?
Yes.
The system is built to settle cases. We can't try all 8,300 cases that we have. The system just can't handle that. We do undergo a risk assessment when we are looking at cases to say, what do we believe the strength of this case is, and therefore, how should we, is it too much risk to go to trial? Is it something we can manage? Or, sometimes a defendant is unwilling to take the deal that we offer, and we maintain that we're not going to go any lower with what form of accountability they need. And so it is worth it to walk in and put it in front of a jury. So, we make those calculations, yes, every day, but they are not always. Sometimes we make a choice not to make an offer because we believe that it is more critical to go to trial and to seek the full scope of the consequence that somebody deserves.
That makes sense. This is all fascinating coming from your perspective because I think it's so easy for the public to rush to judgment. We see this on social media all the time. I know you know. Yeah. And some of the comments that I've seen overwhelmingly are that had this case been tried or had this incident happened in a state such as New York or Texas, the outcome would be different. Do you have any comment about that?
That is hard to say. I think juries everywhere are unpredictable. I do think we have a tough time here in San Francisco. We do. Probably, I would say, tougher than most counties in California, for sure. We have, San Franciscans take their job seriously when they walk into those courtrooms. They are skeptical of the evidence. They want to be convinced that they are doing the right thing. They are very aware of system biases that have come into play over the course of history, and sometimes, I think, overcorrect for what those biases were. I've had jurors, when we are in jury selection say, the defendant is black, I will never, ever vote guilty for a black person because I'm not going to be involved in sending a black person to prison. You would assume that maybe the juror who said that was black. They were not. And so there is an attempt to overcorrect, as I said, things that have happened in the past rather than just focusing on the case at hand. And so a lot of it is about trying to educate jurors that what we are asking for is people to come in and set all of that aside. All we need is you to be fair in this case. But it is hard, so it's hard to say what would have happened anywhere else. As I said, even under the law, this was going to be a difficult case. But I think here, certainly, the juries they hold us to a high standard, for sure.
I think if I'm reading between the lines, there's an element of compassion that I think San Francisco is known for. So perhaps that bled over into the beliefs of the jury. I don't know, but just my observations. Speaking of, we have one great question here. This goes back to the evidence question again, and I sort of touched upon this, but why could Grandpa Visha's picture not be shown to the jury as evidence to show that, in fact, Grandpa was an elder? Could it possibly could possibly a different judge have yielded a different outcome?
I had a discussion with Sean Connolly, who tried this case earlier today, about this question of the picture. I don't understand the court's rulings, to be honest, on that one. A part of, again, our argument was shoving someone the way that he did, who was Grandpa Visha's age, clearly would have the potential to have far worse physical consequences than doing that to someone who was half his age. And so to us, that was very relevant, that not only what his age was, but that it would have been clear, right, to the defendant at the time that Grandpa Visha was an elder. Right, that he didn't think he was pushing somebody younger.
Right.
And so I can't necessarily answer why the judge ruled the way that she did, but certainly it was something, that we believed was relevant.
I told you a lot of people have comments about the judge, and we've got another one. So given the judge has a certain amount of latitude, the judge is human and can be affected by her own beliefs and bias. In a perfect world, those biases shouldn't affect her judgment, but in this case, it appears questionable. I mean, perhaps the way to frame this question is that when you are a judge going through your career, that is one of the fundamentals that you are taught. It is the core value of being a judge, no?
It is. Their job is to be impartial.
Yeah.
And, the truth is, yes, judges come from differing backgrounds. Some were prosecutors, some were defense lawyers, some were civil lawyers, plaintiffs' lawyers, and some, defending clients against those civil cases. So everybody brings in to that job whatever their perspective might have been based on their career, but their job at its core is to set all of that aside. And never have I been somebody who has said the best judges for us are former prosecutors, or the only good judges for us are former prosecutors. It's actually been my experience that sometimes a better judge for me has been a former public defender. They actually, in my view, know the antics, I will call it, of the public defender's office and are more equipped and feel more comfortable calling those antics out and holding them in check. And so, yes, it is possible for things to bleed in, and we see that each and every day, sadly, but I think in this particular situation, again, I believe that it was far more apparent with this particular judge.
I appreciate the candor in that. You'll have to forgive me, the handwriting is difficult for me on this one. But in addition to the years for the court to make their decisions and something about drag on the agony of the victims and the families and supporters, the result of Grandpa Ratanapakdis's case is shocking. To make judges accountable. I don't know if I can translate this. I might have to save this question for a little bit later, or maybe the person who wrote this can clarify. But if we could move on, though, I do think about the family. I do think about the community members that are hurt. Is there anything else that can continue going forward from a legal sense? Because I know that the defendant in a case can appeal a conviction, but is there anything the Ratanapakdis can do?
The short answer is no. We as prosecutors don't hold a right. Victims don't have a right to appeal a jury's verdict. Once that verdict is rendered, that is what we are stuck with. Unlike the defense that can go and file multiple different types of appeals to have that jury to have that verdict overturned or things reconsidered, the law does not afford that right to victims, which tells us a lot about the way that our criminal justice system is set up, sadly. Victims hold very few rights.
Yeah. And speaking of victims, I've gotten to know Montanas and her family over the years. She is tremendously strong, and I know she is hurting a lot. We had asked her to be here, but she is out of town. What I wanted to ask you is, because you actually, during your tenure, created a special unit for victims, and I'd like to ask you what that process has been like and what your involvement is getting to know some of these families of really traumatic crime.
Yes. Ooh. So, I started to get to know some of these families during the recall effort against Chesa Boudin. As almost everyone in this room knows, so many of those victims and their families felt unseen, felt unheard, and did not believe that they were being given the appropriate shot at justice. And so when I was appointed DA, one of the first things I tried to do was figure out how can we better serve these victims, these cases, how can we better handle these cases? Because we had so many seniors who had been victimized. And so what I did was come up with the concept of the Vulnerable Victims Unit, which was a new unit that I created in the office so that more senior level attorneys could take on those cases vertically. What I mean when I say vertically is normally when we have sort of an ordinary felony case that is not domestic violence, sexual assault, or homicide, those cases go first to our preliminary hearings unit. So those are more junior lawyers who put in the first hearing that we need to have before a judge. Sometimes they'll negotiate making a plea offer. And then if the defense rejects the plea offer and they put in the hearing and the case continues, that case then gets handed off to a different attorney that is assigned to the General Felonies Trial Unit. So in those cases, you start off with one lawyer and then you get handed off to another lawyer, which can oftentimes be a little jolting for victims. And when we're talking about such sensitive cases, victims who need a lot of assistance through this process, oftentimes, and when I took over, most of those victims were monolingual Cantonese-speaking victims who needed to have their hand held through this process more closely. And so what we did was, when I created that unit, it meant a more senior lawyer that was taking that case from start to finish, from the first appearance all the way through trial if the case goes to trial, so that there wasn't that disconnect of having the case handed over to someone else, that it wasn't junior lawyers handling it. That unit was paired up and is paired up with victim advocates who are bilingual, who are attached just to that unit. And so it allowed a more cohesive team to be handling those cases with more care and ensuring that, you know, when it's more senior lawyers, that they know what they need to do when they walk into that courtroom to prove those cases. And I think that it has really assisted us in being able to maintain the cooperation of those victims who oftentimes don't want to be a part of this process, as you can imagine. It allowed us to better keep them and their families updated about what was happening in the court process, and generally to allow us to be more successful at the end.
Because I can't tell you how many cases I've covered where I will ask a member of the family, hey, when's the next court appearance? They have no idea. They also don't know what's happening or what each step of the legal system means. So they need a little bit of hand-holding. They need extra care.
Yes.
So I see the need.
And sometimes we have elderly victims who, you know, are very elderly, or the attack has left them in a physical position that is not that well. And so oftentimes those cases require what we call in the law is a conditional examination. It means that we, early on in the case, bring that witness to the stand and allow the defense to question them as well as the prosecution. It is recorded by video so that their testimony is preserved for a future trial. Sadly, if something doesn't allow them to testify in the future. And so, again, those are things that have to be handled with care. Those are decisions that are critical and that have to be made. And so, again, why it was so important to have that unit formed.
It makes complete sense. We do have another question. It does touch upon judges again. Oh, I know.
You guys are trying to get me in trouble tonight.
Judges are critical in the criminal justice system. How can they be held to a higher standard? What about public defenders? Are they held in the same professional standards as the district attorneys?
You know, I get this judge question a lot, and I've tried to answer it over time that there is not a lot that can be done. Certainly, we have the ability before the verdict to appeal certain rulings. I'm not saying we don't have any appeal rights. We can file appeals on certain rulings pre-trial. Most often, if we believe that a judge was just patently wrong on the law, we have the ability to disqualify judges from hearing a certain case if we believe that they are biased in a way that will prejudice our case. So you have heard, I'm sure, of me authorizing my office to challenge a number of judges and disqualify them from hearing our cases. Most of that accountability has to happen by the DA's office in just the process that we have. Yes, judges are subject to elections every 6 years, but as most people also know, they don't show up on our ballot unless they are challenged. And as most people have learned, that is not an easy race to win. And so for the most part, what I have tried to tell people is we do need to be present in these courtrooms. They need to know that what they are doing is not happening in a dark silo where no one is paying attention, where it won't come to light. You can imagine how much vitriol I have gotten about being so transparent about decisions that they have made, and I will continue to do so. I believe that the people of this city are entitled to know what happens in their courthouse.
Agreed.
And so I think that calling it to light, making sure that the public is engaged, they see that. They don't want, their decisions to be in the news either. And so helping people to assist with that transparency, I think, is the biggest thing that we need to continue to do.
We have another question about a judge, but I'm going to put this on pause.
Oh, and I didn't get to answer about the public defenders.
Oh, yes, please.
Sadly, they are not held to the same standard. They are not. Prosecutors have ethical obligations that are really the highest of anyone in the courtroom, because we, hold the future liberty of the defendant in our hands. And so we have to live by that ethical standard. I tell my lawyers every day, who often are dealing with unprofessionalism, things, unethical behaviors happening from the defense each and every day, that our job is to maintain our level of ethical and professional responsibility, right? We do not reduce ourselves to the way that they act. We do have the ability to file complaints about their behavior. We can file if it crosses a certain ethical line, state bar complaints. There are recourses that we have if it gets to a certain level, but it is common that we experience a vast degree of unprofessionalism and unethical behavior on the part of the public defenders.
I was waiting for it. On the flip side, from a journalism perspective, we always talk to the public defender afterward, right? Because they're so eager to speak. And some of them are very rude and very outrageous. You don't have to say anything. I'm just putting it out there that it became almost a joke with one of my photographers at the time. On the flip side, you'll be relieved to hear, this question comes in and asks, do you believe that prosecutors on the case are qualified in terms of experience to present cases to the jury? What impact do you believe that the experience has, I believe, experienced prosecutors on the case had on the result of this case? I think it's a question about experience.
Yeah. So experience absolutely matters when you talk about being a trial attorney. Graham Pavicha's case was handled by one of our most experienced lawyers, who I had every faith in could present this case appropriately and was prepared to argue the things that needed to be argued. He's been not only an attorney, but a trial lawyer for decades. And so that matters, and that is something that we pay attention to. That's why our office is set up a certain way. So in order to be in our homicide unit, those are our most experienced lawyers. Unfortunately, you can't quantify it just by years. When I entered our homicide unit myself, I'd been a prosecutor for about 5.5 years. That is not as much as, other people in our office. But I had tried a lot of cases in those 5.5 years that allowed the office to trust that I was ready to do that. And so we are constantly looking not just at someone's years of tenure, but of the level of trial experience that they have gained, not just by number, but it's quality and quantity. What complex trials have you done? All those types of things as we look at assigning people to units that handle more serious and complex cases. And so that most certainly matters, and it's something that we take into account each and every day.
I will not give you this question quite yet because I'm looking at the clock and I want to make sure we get to our other case. But I want to get back to the issue of hate crimes because this comes up again and again. And I think from my perspective, oftentimes after there's a crime committed on a community member who is of a different background, the first thing that comes to mind from the public is this a hate crime, or it's got to be a hate crime? But I think what many people don't understand is that the bar is set in a way where the case needs to fit certain parameters in order to meet that threshold. In the case of Graham Pavicha and Popo Huang, they were not categorized as hate crimes. Why is that?
So hate crimes are one of the most difficult things to charge. I spent almost 2 years as the assigned hate crimes prosecutor in the DA's office over my time as a line prosecutor. And it is one of the only crimes in the penal code that requires us to prove motive. Right? For a robbery, for a murder, for anything else, we don't have to prove why you did it. We just have to prove that you did it. Hate crimes are different. We have to not only prove what you did, but we have to be able to demonstrate beyond a reasonable doubt that what motivated you to do whatever you did was hate, bias, or animus. Proving what was going on in someone's head can be very difficult, particularly when they don't say what they are thinking, right? Or put on a wall what they are thinking. So hate crimes that are vandalisms tend to be more simple, right? Because somebody has put a swastika on a wall or a racial epithet on a wall. If it is a hate crime where they say a racial epithet as they are committing the assault, it's very clear perhaps what is going on in their minds. But when they don't, that's when it becomes much more complicated. In Grandpa Veach's case, we had no, and I'm going to start there, we had no evidence that the defendant was motivated by Grandpa Veach's race or honestly even knew what it was at the time. We did believe he could see his age, certainly his gait, because we know that the way he walked suggested he was an elderly person. But we actually had evidence to the contrary based on jail calls that put into question whether he was aware of his race at the time. And so that is what precluded us from filing a hate crime charge in that case. In Grandma Wong's case, as you heard, this was an individual who didn't mind robbing people violently. And so it appeared that tended to be his behavior, but also, again, we lacked anything to prove that what motivated him to be so brutal with her and to choose her as a victim was hate or bias. It doesn't mean that that's not the case. It just, that wasn't what he was thinking. I can't say one way or another. What it means is we have to have proof beyond a reasonable doubt. That is our burden, and that ethically we can't charge that without believing that we hold that proof. And so that's the bind that we are in and why they weren't filed in those two cases.
I remember you told me a story earlier about an individual who was robbing Asian females, correct?
It was assaulting, yes.
Assaulting. In that case, can you share with everyone the particulars and how you were able to get those hate crime charges?
Yes. So when I was the hate crimes prosecutor, I dealt with an individual who initially picked up 2 assaults of Asian women at bus stops. And then I got additional police reports involving this individual assaulting more Asian women on buses or at bus stops. And he never said anything to them. But the fact that his crimes were so violent and they were consistently targeted towards people who looked exactly the same led me to believe that I could prove that he was motivated by their race and that it was clearly hateful because he was violent towards them. And so it doesn't require that somebody say something. I want to be clear. We can prove hate crimes many different ways. Sometimes it is circumstantial, right? That would have been circumstantial evidence because he didn't say it, but his behavior suggested a pattern of choosing his victims and being very hostile and angry and violent. But it's each case is so specific and so unique that we are looking at each one to see, do we believe that we have enough? That was a situation where I believe there were 7 or 8 women who were attacked that led me to believe I had enough to prove it in that situation.
And they were all Asian American?
Correct.
Wow. This question is a little bit unique, so Brooke, you get a break because this one's for me, apparently. How can the public support unbiased reporting in the mainstream media on crimes affecting Asian American Pacific Islander communities? From coast to coast, AAPI reporters seem more scrutinized than, I think this says the rest of maybe the newsroom. I will say this, is that Asian Americans are underrepresented in media across the board. The National Association of Asian American Journalists did a study not long ago showing, I use this example because it's the easiest one to swallow, that newsrooms are made up of 1% or less Asian males. And it's not just the people in front of the camera, not just the reporters themselves, but the people behind the scenes that matter. So when you have a small pool of people lobbying for stories in this Asian American community, it is hard to get your voice heard. And I think it is more important now than ever when, with this current administration that we have, and media, again, across the board, not just television, but also print, every single mainstream outlet is being watched by our president. It matters when you are that voice inside that newsroom. So I think more often than not, if something doesn't feel right in the bottom of your gut, you need to stick to your guns and say something. Get an ally within your organization to repeat that something when you are in a group. The fight continues. It is going to continue and be a more uphill battle. So I think if you can also, in other ways, support those journalists by retweeting, sharing their content, that is true amplification, and that's how you fight it from the inside out. So that is my response to that. Thank you for the question. I want to move on to Grandma Huang's murder. I remember standing in that Visitation Valley playground back in 2019. Sasana Yi, her daughter, was so heartbroken, so terrified of sharing her story. It took about an hour of me trying to convince her, please share this with the world. And even though she has since become very bold and very strong and outspoken, she's obviously been hurting, and that hurt has been prolonged because it's been more than 6 years. And can we talk about why this trial has gone on for so long and there is still no resolution?
Well, he has not been sentenced. That is correct. So there's no finality yet. While there has been resolution, there's no finality. One thing that I try to explain to people about the criminal justice system is that the prosecutors do not hold the power to determine the pace at which a case goes through the system. So often you will watch news stories and hear people speak who say, the prosecutors delayed this case. The prosecutors, didn't take it to trial faster. While yes, there are ways that we can somewhat delay, the defendant is the only one with the constitutional right to a speedy trial. And if they invoke that right, we are held to a very high bar to prove that we deserve any delay beyond what that right is. So that right is 60 days from the time that right is invoked, that we have to begin the trial. And there has to be a good cause reason that we are able to delay. Otherwise, that case can be dismissed, or at the very least, the defendant released from custody. So there is no way for us to speed it up. But what we often see happen are defendants be advised not to invoke that right, to allow these cases to languish. And you're saying, well, why would they want that? Wouldn't they want finality? When they see that a case is strong for the prosecution, there is no incentive to rush their way to prison. What they are, I believe, told, but at the very least understand, is that over time, memories of witnesses fade. We lose contact with people because witnesses move, right? Nothing keeps them here. People change phone numbers. People move from state to state, city to city. People grow frustrated with a process that has taken years. We have officers that investigated a case or responded to a scene that retire or transfer departments. And so as time goes on, it becomes harder and harder for us to produce the full scope of evidence of the crime that was committed. So they have an incentive to delay. In this case, in particular, we had a situation of a defendant who started off with attorneys that he would over time grow displeased with, or at least he said. And so every time you change attorneys, that attorney has a right to get up to speed on the case. They have a right to be prepared They have an obligation to be prepared, which takes time, certainly when you're talking about a murder. And so that is a part of it, was the transition between lawyers and then ultimately his decision to represent himself. And now we are in a delay because following the verdict, he did alert the court that he was demanding an attorney. And at this point in time, the court has appointed him an attorney. And in large part, that happens because if the court did not, there is a high risk of an appeal. This is a person who now is saying, this is another phase of this case, and I want an experienced lawyer. And so the court, quite frankly, was obligated to give in to that request.
And I remember being in that courtroom, and that was the case, and we all wondered, how long is this going to be delayed? I mean, to go through all the notes of a case can take, what, months, you think?
Oh, absolutely. And this is a lawyer who now needs to likely review a trial transcript for a trial that took weeks. So this is somebody who has to be up to speed and has to be given the time to do so while they manage other cases on their caseload.
I have to ask you this difficult question as well. Do you think that justice has been served in these cases?
You know, when I think of Grandpa Vicha, Brooke, the person, says no. And I say that because I think, much like anyone, it is hard to understand how you can take the life of such an innocent man who was doing nothing but minding his own business, who had the right to live out the rest of the years that God would grant him with his family on this earth, that you could take his life and never set foot in a state prison, that you could take his life and in a way it feels like game the system so that you would never set foot in a prison. And what I mean by that is the more credit you accumulate in the county jail, the less likely, if you get a verdict like we got, you are to go to prison. And so I think for me, that does not sit well as the person. It doesn't. And I think most humans would say that. Grandma Wong, I do believe in her case, in some sense, we have gotten justice. He will go to prison for what he did. Is the delay fair? No. No family should have to wait that long. No family should have to endure what they've had to endure to get to the point where they are allowed to begin fully healing, right? You don't ever really heal, but where they don't have to keep dealing with this. I announced a conviction today. We had a trial of the rideshare rapes that occurred back in 2018. That case was filed in 2018. This is how long it took to get to the point of verdicts for 4 separate rape victims and what they've had to endure over this time. It's not unique. This is something that happens each and every day in this system. And that doesn't necessarily always feel like justice, although we do our best to make sure that at the very least we provide what we can, which is, again, in Grandma Wong's case, a guilty to the murder.
Yes. How are families, how are people such as those in the audience going to move on and have feelings about the justice system? What can we do to feel not so, so in despair?
I think much like the lawyers in my office, you have to fight to see another day. You have to keep fighting. We don't have the ability to give up. We don't have the ability to stay there. We have to keep fighting for the next victim, right? We have to keep doing what we can to prevent the next victim. And I think that's what this is about. It's also about, I think, understanding that and recognizing that this is not a unique feeling to so many victims in this system. So many families, so many people who have been victimized of all demographics, of all incomes, who have been left holding this bag as well. And I think uniting around that common experience is important, because that is what keeps us fighting, like I said, for the next family that ends up in this situation, or the next community member, right, that is victimized, that needs people to stand up and advocate.
And it's interesting because I look out on our audience and I'm always in awe when it is not just Asian Americans who want to show up and to speak out, but when we have a breadth of different backgrounds coming together to have this discussion, to deep dive a little bit more. I'm sure you must see something similar in the rallies that you've attended or what you've seen out in the community at the events you're at.
Yes, and I have to say, the most unity that I saw in the last 4.5 years was the recall. And I know a lot of people in here were a part of that effort. And I have to say, people from all over this city, every neighborhood, every demographic came together saying, we demand justice. We demand accountability. We all want that. And I think we can't let go of that. It was that coalition that got that recall across the finish line. And it's going to take that coalition to make sure that we plug the holes that are in this system that have left us feeling what we feel right now. Because every community feels that at times, right? And so I think I still see it, but I haven't seen it as much as I saw it during the recall. I think we still need to make sure that we are coalition building.
That was an intense time.
It was.
Y'all know that I know firsthand. We have two last questions that I'd like to get to because I'm looking at the clock. Is there a limit on how many times the defendant can change attorneys? How can we change how prolonged the process of these murder cases, and what can we do to help put criminals behind bars?
So there are parameters around when the court allows defendants to, quote, fire or get rid of their attorneys, change attorneys. It's not as though they can just walk into court and say, I just want a new attorney. They hold hearings. They have to make certain certain things have to be established with the court in order to justify that happening. And so that does somewhat control how often or how frequent they can do it, or if sometimes they can do it at all. What was the second part of that?
There were lots of questions on this. What can we do to help put criminals behind bars?
Report crime. If you see something, be willing to be a witness.
Yeah.
Don't toss out your jury summons. Or even if you adhere to it and you show up, don't be the first one raising your hand saying you have a hardship. I wish I could serve on a jury. I am jealous of those who get to serve on juries. I will never be selected. It just won't happen. But those are the main ways. So often we are having to really persuade people, to engage in reporting crime. And every day we experience the reluctance of witnesses to cooperate with, not just telling the police what they saw, but coming into courtrooms and testifying about what they saw. Victims need people to speak up. Because when you're in the middle of that trauma, oftentimes they can't articulate what they saw or what color shirt someone was wearing because they're in the throes of, being attacked. And so we need eyewitnesses that are willing to cooperate and help. And like I said, we need sound jurors.
Piggybacking off of that last question, what can be done to expedite these trials?
As I said, not much. One thing that I told my staff when I took over was we must be prepared. We should not be the ones who are saying we are not ready, first and foremost. The second thing is, what we should not be is passive about accepting when the defense continues to ask for delays. In most cases, we are back in court once a month to appear on a case, to check in with the court. And in those cases that languish for years, oftentimes what's happening is that the defense is coming in every month and saying, I need more time. I need more time. When some of our lawyers are dealing with, some of them, hundreds of cases. In our homicide unit, they have on average 15 homicides. When you're in trial on one, it's easy sometimes to allow yourself to say, okay, they can have a continuance. That gives me more time also. But it's me demanding of them that when we see these intentional and strategic delays, that we really, for lack of a better way to put this, jump up and down and scream. Because we don't have a right to stop it. We can't, again, invoke a speedy trial right for the victims. But what we can do is argue to the court that the court needs to be more aware of what's going on, and the court needs to press on the defense to stop, right? That if they want more continuances, that they need to be able to articulate why they need more time if they've had a case for 2 years, 5 years, 8 years. But unfortunately, like I said, we're very powerless in most of these situations to do anything about it. And it's hard. It's hard on the victims, and we know that. And it's hard on us as lawyers who, for sometimes 5 years, are trying to keep this case together at the seams.
I know we only have a few minutes left, but can you leave us on a somewhat hopeful note?
I would say to all of you, we have to continue, like I said, to fight and to advocate. We have to continue to do it as that coalition. When we were talking earlier today, I said, so often I do walk into rooms that are very demographically homogeneous as the DA. And some of that, is normal. It's a cultural celebration, right, or a cultural event. And of course, it's going to it's going to reflect the culture that we're there to honor or to celebrate. But making sure that at a time when our country is so polarized, that we lean on each other to advocate for each other, that we don't allow these moments in time and the frustration that we feel to make us feel isolated, and that we can only depend on the people that look like us. I think this is a moment where, I think we have to make sure that there is more unity. I told Dion earlier today, I would love to see a group of teenagers from all over this city who look a million different ways go in and volunteer with Self-Help for the Elderly, right? That's how you grow empathy. That's how you look at those seniors who I find to be the most sweet and adorable people, who you want to help do anything. I mean, literally, whatever you can do to help them in that moment. We have to teach it now, right? With our kids. They're living on devices. They're not interacting with people anymore. And we have to get back to a place where we bring them in so that they become the protectors of those seniors. They feel an obligation to look out for those seniors. And I hope that we can take this frustration and we can use it towards good. The hope comes from this last 4 years, right? That began with more attacks on Asian Americans than many of us could count and or stomach. That we have gotten beyond that. Not to say that we don't have any incidents. No, of course we still do. But we're nowhere near where we started off 4 years ago, 5 years ago. How we started off with a DA that didn't give a damn. And now we've got an office that not only is doing the work, but is giving every ounce of itself to fight for the justice and to do it the way that the community deserves, right? We have to continue that fight by making sure that we are getting the right elected officials in every position, that we are educating each other on what these people stand for. And as most of you know, holding them accountable. And so I think, from 2020, 2021 to now, thanks to the people in this room, we have come a long, long way. That's the hope. The hope is that if we keep at this, we'll get to where we need to be.
San Francisco's District Attorney Brooke Jenkins, everyone.